On Bottom Line Africa, for newly developing story, Supreme Court judges have already entered the courtroom to deliver the ruling on a petition against the election of Wajir Governor Mohamed Abdi. The top court has been on the spot over the delay in the delivery of this decision, and we can see from our live pictures, Chief Justice David Maraga is already speaking. Let's go over there live and listen in.
In this appeal, I agree with the factual background and the summary of the submissions advanced by the parties. I do not, therefore, need to rehash those facts in this dissent. With profound respect, I'm, however, not in one with the majority decision and the final orders they have proposed. The major issue in this appeal is whether or not the appellant possessed the requisite academic qualification to fire in the Wajir gubernatorial context, which I will hereinafter refer to as the election. By its order of the 28th of September 2018, this court granted the appellant leave to adduce additional evidence on his academic qualification to contest in the election. In the circumstances, this court, in my view, has to consider the additional evidence adduced by the parties. As such, before I consider the written submissions filed by counsel for the parties and their oral highlights, I need to summarize the additional evidence attended by the parties pursuant to our ruling of 28th. I have summarized the evidence. As I said, I don't want to go into all the evidence that we have summarized. The academic qualification, having considered the grounds of appeal, the issues raised by the interested party, the respondent's notice of affirmation of the Court of Appeal decision, and the rival submissions tendered by the parties, I find that there are 7 issues that arise for the determination of this court. They are whether or not this court has jurisdiction to entertain this appeal, whether or not the appellant had the requisite academic qualification to fire for the election for the position of Wajir governor, whether or not the High Court, as the election court, had jurisdiction to entertain the pre-election nomination disputes, notwithstanding the provisions of Article 88 4E of the Constitution and Section 74 of the Elections Act, whether or not the 2 superior courts floundered on the burden of proof in electoral disputes, whether or not the conduct of the election was fraught with irregularities and illegalities which undermined its integrity and affected its results, whether the deputy governor's election can stand on its own, and lastly, whether or not the Court of Appeal abdicated its duty when it determined the appeal on only one ground and refused to consider the others. To start with whether or not the court has jurisdiction, I have considered the authorities and the past authorities, and my view is that the academic qualification of a university degree as a criterion for eligibility to contest in a gubernatorial election, though expressly provided for in Section 22(1)(b)(2) of the Elections Act, has its anchorage in Article 180 and 193 of the Constitution. I agree with the appellant that the issue of his academic qualification for election as the governor of Wajir County was central in the proceedings before the 2 superior courts. It was raised in paragraphs 21, 28, and 29 of the petition before the High Court, and formed part of the failures the High Court had in mind when it stated at paragraph 208 of its judgment that the Wajir gubernatorial election was not conducted in accordance with the Constitution and the law. This decision was based entirely on the High Court's finding that the secrecy of the ballot was breached, thus violating Article 81(c)(1) of the Constitution. These, in my view, are clear issues of constitutional interpretation and application, and on my part, I have no doubt whatsoever that this court has jurisdiction to determine the appeals. Now, on whether the second issue is whether a university degree is a prerequisite for a gubernatorial election. Counsel for the appellant submitted that although the appellant has a bachelor's degree in business administration and even a master's in international diplomacy, by dint of Section 22(1)(a) of the Elections Act, introduced by Section 8 of the Election Laws Amendment Act number 1 of 2017, the requirement of a university degree qualification prescribed by Section 22(1)(b)(2) of the Elections Act as the minimum academic qualification for election as an MCA and or governor was deferred to the first election after the 2017 general election. In my view, this contention is not correct. I've set out the section and I have analyzed the aspects and the amendments to that section. It is clear to me that the said 2012 and 2017 amendments to Section 22 of the Elections Act specifically targeted the position of members of parliament and MCAs and not those of the president, deputy president, county governor, or deputy county governor. And for good reason. It is common knowledge that in 2000, the Constitution of Kenya Review Commission was established to spearhead constitutional reforms in the country. During the constitutional review process, the Commission collected and collated views from the public. An overwhelming majority of members of the public called for prescribing educational qualifications as a prerequisite to contest for various positions. In its final report of 2011, the Task Force on Devolved Governance observed that in light of the important function of implementing both county and national legislation, as well as managing and coordinating the functions of the county establishment and administration and its departments, that the county executive, headed by the governor, will be required to perform. The requirements of competence and suitability can only be operationalized through educational and professional qualifications. It is on the basis of these recommendations that Article 193(1)(b), read together with Section 22(1)(b)(2) of the Elections Act, that the academic qualification of a university degree for election of gubernatorial position was inserted. As stated above, the 2012 and 2017 amendments did not change this requirement for election as a governor. I therefore find that the academic qualification of a university degree is a prerequisite for election to the position of a county governor and even the deputy governor that applied in 2013 and 2017 general elections, and unless specifically amended, will apply in the future. In this case, it is the first respondents now moving to the third ground, whether or not the two superior courts floundered on the issue of the burden and standard of proof. In this case, it is the first respondent who alleged that the appellant's degree certificates were not genuine. By dint of Section 107 of the Evidence Act, he bore the burden of proving that allegation. I do not think that the use of the term forgery in his pleadings connoted a criminal or quasi-criminal intent requiring proof beyond reasonable doubt. It was an ordinary challenge of the authenticity of the appellant's said certificates, which, as is the law in electoral disputes, required proof to a standard higher than a balance of probabilities, but below beyond reasonable doubt. See the case of Raila 2013. I concur with the Superior Courts that the first respondent placed before court evidence that the petitioner's name was not on the list of graduates of Kampala University for the 1st March 2012 graduation. There was also evidence that the minutes of the Departmental Committee of Defense and Foreign Relations on the vetting of the appellant for an ambassadorial position, it was stated that although the appellant, and I quote, joined Kampala University to pursue a bachelor's degree in business administration and a postgraduate diploma in international relations, he is yet to graduate. That, with the appellant's self-declaration that as at May 2017, his highest academic achievement was a Bachelor of Business Administration, cast doubt on the authenticity of the appellant's certificates and successfully shifted the burden of proof to the appellant, but he failed to prove to the contrary. Now I move on to the issue whether the appellant possessed the requisite academic qualification. On 3rd of September 2014, the appellant appeared before the Parliamentary Departmental Committee on Defense and Foreign Relations for vetting as to his suitability to serve as the Kenyan ambassador to Saudi Arabia. The committee's report annexed to the first respondent's affidavit sworn on the 11th and filed on the 12th October 2018 states that the appellant, and I quote, joined Kampala University to pursue bachelor's degree in business administration and a postgraduate degree in international relations, and is yet to graduate, at the end of quote. I reject the contention by counsel for the appellant that the phrase in the report that the appellant was yet to graduate referred to the graduation in the postgraduate diploma in international relations. That contention does not flow from the above quotation and or from the report as a whole. This is because prior to the appellant's appearance before the said Parliamentary Committee for vetting on 3rd of September 2014, the Clerk of the National Assembly had advertised in the Daily Nation of the 26th August 2014 a notice requiring nominees for various positions to appear for vetting on various dates. That notice required all candidates to go to the vetting sessions with the originals of their identity cards, academic and professional certificates, and other supporting documents. Besides the appellant, two other candidates, Mr. Richard Opende and Lucy Chelimo, were also vetted on the same day, that is on the 3rd of September 2014, for the positions of ambassadors to Ireland and Canada respectively. In respect to Mr. Opembe, the committee's report records that he held a diploma in sales and marketing from Transworld Tutorial. While in respect of Ms. Chelimo, the report states that she had joined Kenyatta University where she earned her Bachelor of Science degree in environmental science. From the advertised notice, it is clear that each candidate must have appeared with his certificates. If one did not, one had to have an explanation for that failure. The report of Mr. Opembe and Mr. Chelimo left no doubt about their respective qualifications. As observed, the report states that Mr. Opembe was a holder of a diploma, while Ms. Chelimo was a holder of a degree. For the report to be that categorical, they must have produced their certificates as required. It follows, and I agree with the counsel for the first and the second respondents, that the reason why the report in respect of the appellant reads, and I quote, he is yet to graduate, is because he was not able to produce those certificates. A report of that special session, also annexed to the first respondent's said affidavit, makes it quite clear that a nominee's academic qualification was an important criterion for approval of his or her appointment. If the appellant had a university degree, he would have been happy to flash it rather than risk the disapproval of his appointment. Evidence was tendered before the trial court that in support of his application for nomination to fire in the Wajir gubernatorial contest in 2017 general election, the appellant swore a statutory declaration in which he stated that his highest qualification was a bachelor's degree. That contradicted his avowed contention that he had a master's degree, which overqualified him for the gubernatorial position. The appellant claimed he was cleared after the booklet that was published. I will read that, the whole sentence. Further, it is common ground that the names of the students from Kampala University who graduated on the 12th of March 2012 were published in the graduation booklet for that year, and that the appellant's name was not on it. The appellant claimed he was cleared after the booklet had already been published, and that's why his name appeared on the dean's list of the other students who were allowed to graduate. The explanation is untenable for two reasons in my view. One, to his own affidavit, the additional evidence sworn on the 7th of October 2018, the appellant annexed a clearance form showing that the last department in Kampala University to clear him was accounts, and that was on the 13th of December 2011. I agree with the first and the second respondents that the graduation booklet cannot have been published before that date, which is more than 2 months prior to the graduation date. Secondly, on my part, I entertain doubts on the authenticity of the dean's list, as it was signed by the academic registrar and not the dean himself. This is, of course, besides the unresolved dispute as to whether or not the dean's list is a graduation list. Consequently, I have no option but to affirm the concurrent Superior Court findings that the appellant did not possess the requisite academic qualification to contest in the election, and that his election was therefore null and void. I now move on to the other issue, whether the High Court had jurisdiction to determine the issue of pre-election nomination dispute. In my view, a contextual interpretation of Article 88.4e divides into two categories the election pre-nomination disputes therein referred to. The first category comprises the disputes which are founded under the general rubric of the constitutional qualification or eligibility criteria to contest in the election as set out in Article 99 for the members of Parliament, Article 137 for the President, and Article 193 for the members of the County Assembly. The second category includes intra-party nomination disputes contemplated by Section 31 of the Elections Act, such as whether or not one was properly selected under the rules of the political party concerned relating to the members of that party who wish to contest in a given election, which the political party's dispute tribunal may or may not have resolved under Section 41 of the Political Parties Act. Under the disputes under Section 34 of the Elections Act as to whether one's name should or should not be on the political party's list. This category of disputes are not founded on any constitutional criteria and do not therefore go to the route of the election. In my view, IEBC has exclusive jurisdiction to determine this category of disputes. It should therefore determine them with the finality, subjected to any appeals in accordance with the procedure set out in the Elections Act, and the Election Court has jurisdiction to determine them. I believe there is no contestation that the Constitution has vested the courts with overarching jurisdiction to determine the validity of elections. This is clear from Article 140, which vests the Supreme Court with jurisdiction to determine presidential election petitions. Article 105(1)(a), that vests the High Court with jurisdiction to determine petitions challenging the validity of parliamentary elections. Section 75(1) of the Elections Act, that vests the High Court with jurisdiction to determine, and I quote, a question as to the validity of the election of the county governor. And Section 75(1)(a) of the Elections Act, that vests the subordinate court with jurisdiction to determine petitions challenging the MCA elections. Having considered the rival submissions and the authorities, both sides cited in support of their respective contentions, I find that contrary to the appellant's contention, academic qualification being a mandatory prerequisite for eligibility to vie in a gubernatorial election grounded in the Constitution, it is a matter that goes to the root of the gubernatorial election that forms the general ground upon which such an election can be challenged. Support for this view is found in the case of Kenneth Moki versus Rachel Kakai Nyamai, in which the Court of Appeal stated, and I quote, eligibility and qualification to vie and contest in an election is an issue of substance that goes the root of the election, and an election court has jurisdiction to hear and determine that dispute. It would, in my view, be tragic if, through a slip or even a fraudulent process, a person who is not a Kenyan citizen and does not meet the other criteria set out in Article 137 of the Constitution is elected president of this country. It would be tragic if a person who does not meet the criteria set out in Article 99 of the Constitution is elected to Parliament. It would be tragic if a person who does not meet the criteria set out in Article 193 of the Constitution is elected an MCA. It would be even more tragic if the election court, leave alone this court, were to interpret Article 88(4)(e) as a fetter of its hands to determine any pre-nomination dispute and let such an obvious illegality to stand. In a nutshell, I'm saying that the IEBC has unquestionable jurisdiction over under Article 1, under Article 88(4)(e) to determine pre-election nomination disputes. It has exclusive jurisdiction to determine with finality, subject to appeal or judicial review, all intra-party nomination disputes. However, a holistic and, as required by Article 259, harmonized interpretation of Articles 81, 88, 86, 99, 105, 137, and 140, as well as 193 of the Constitution, read together with Section 75 and 83 of the Elections Act, leaves me no doubt that the election courts also have jurisdiction to determine pre-nomination disputes which go to the root of an election, especially those that IEBC has not determined on merit, like the one giving rise to this appeal. If to determine the validity of an or integrity of an election, the election court is required and has jurisdiction to consider election principles laid down in the Constitution, how can it jurisdiction to consider imperative constitutional provisions to be hosted. I have no hesitation in finding that in this case the High Court, as the election court, had jurisdiction to determine the validity of the pre-nomination dispute that questioned the appellant's educational qualification to contest in the Wajir gubernatorial election. I mean, now coming to the issue of whether or not the deputy governor's election can stand alone. That brings me to the case of the interested party, the deputy governor. His contention is that the position of deputy governor is elective. Upon being satisfied that he possessed the requisite minimum academic qualification of a university degree, IEBC cleared his nomination and he successfully contested in the election. In the circumstances, he urged that even if we uphold the Superior Court's finding that the appellant was not qualified to fire in the election, that will not affect his election. That will only create a vacancy which, in terms of Article 82 of the Constitution, he said he is able and competent to fill. I have no difficulty in disposing of this contention as untenable. The vacancy in the position of a governor referred to in Article 182 of the Constitution is it 182 or? Is it on page this? Yes. 182 of the Constitution arises after a successful and unchallenged election or after the same is duly upheld in the case of an election petition challenging it. In this case, having upheld the nullification of the governor's election, which with due respect I find that the interested party's contention has no legs to stand on. The last issue I want to consider is whether this court has jurisdiction to determine issues the Court of Appeal left unresolved on the doctrine of mootness. The phrase matters of law only in Section 85A of the Elections Act does not mean that the appellate court has to steer clear of the evidence on record, as the Court of Appeal appeared to imply in this case. As was stated in the case of Munya, this court observed, and I quote, "In considering matters of law, an appellate court is not expected to shut its mind to the evidence on record. Instead, an appellate court has to consider the evidence on record to determine if the trial court's conclusions of law drawn from the facts are reasonable and in accordance with the spirit and the purpose of the Constitution. Rather than go into the calibration of evidence and reach its own conclusions, an appellate court has to have a paranomic view of the evidence on record and determine if it speaks to the legal issues raised and or involved in the case as the trial court found." The issue of the unconstitutional conduct of the election, which the High Court found vitiated the election, was prominent in the appellant's memorandum of appeal and the third and fourth respondents' cross appeal to the Court of Appeal. While in their written and oral submissions, the appellant and the third respondent faulted the trial court for magnifying what, in their respective views, were minor irregularities as founding a cause to void the election, the appellant applauded the trial court for finding that the conduct of the election was not fouled. In particular, the constitutional principles on the secrecy of the vote. In its petition of appeal to this court, The appellant has complained against the Court of Appeal's failure to consider all the third and fourth respondents' grounds of the cross of appeal before it. The third and fourth respondents' grounds of appeal, the Court of Appeal declined to determine, are the same ones of unconstitutional conduct of the election, which the High Court found vitiated the election. As is stated, these are the grounds upon which the appellant urged us to assume jurisdiction of the Court of Appeal and determine. The first and the second respondents, on their part, urged us to uphold the Court of Appeal decision on the doctrine of mootness and declined to entertain them. In the alternative, however, the first and the second respondents argued that even if we consider on merit the grounds the Court of Appeal left unresolved, we shall reach the same conclusion as the trial court and affirm its nullification of the election. Sections 20 and 21.3 of the Supreme Court Act and Rule 3.5 of the Supreme Court Rules 2012 provide for assumption by this court of the Court of Appeal's jurisdiction to determine issues it omitted or refused to determine. I have analyzed those provisions and stated that these provisions this court should sparingly, these are provisions this court should sparingly invoke. They should be invoked in clear cases where an issue was squarely raised in the Court of Appeal, but the Court of Appeal failed to resolve it. In addition, they should be invoked when the interest of justice so demands. Upon evaluation of the evidence, as the Court of Appeal should have done, I find that the trial court's conclusion that the conduct of the election fouled the Constitution and affected its result is well founded on evidence on record. I also find that the Court of Appeal would have reached the same conclusion had it considered the other grounds. So even if I had found that the appellant had the requisite academic qualification to find the election, I would nonetheless have upheld the trial court's finding that the conduct of the Wajir gubernatorial election violated the constitutional principles and affected the result of the election, and accordingly upheld the nullification of the election. In the result, on my part, I find no merit in this appeal, and as to costs, they ordinarily for the event subject to the discretion of the court in the unique circumstances of this case. In this case, I see no reason why I should deny the first and the second respondents their costs. Consequently, I would have dismissed this appeal with costs to the first and the second respondents. However, as the majority have hold a different view, the final orders of the court shall be those proposed by the majority. In the dissenting opinion of the Honorable Justice Lenaola, he agrees with me partly and disagrees with me partly and agrees with the majority. So I will not read the whole of it. He says, I have read the majority decision, and with respect, while I agree with the background of the appeal, I'm not in agreement with the decision and orders proposed by my learned sister and brothers. I have also read the dissenting opinion of the Chief Justice and the President of the Court. I agree with the rationale for his dissenting opinion and the proposed orders, save for my comments as below. My separate and the brief dissenting opinion seeks to reaffirm and clarify two issues. In what circumstances should an election court assume jurisdiction of a pre-election dispute, and the extent of this court's jurisdiction in considering matters that were not determined by the Court of Appeal. The judge has analyzed the issue of when the election court should determine a pre-nomination dispute, and in his view, it is when the dispute under Article 1, under Article 84, 88(4)(e) is not resolved on merit, that is when the court can assume jurisdiction, like in this case, where, as you know, the dispute, the pre-nomination dispute launched by one voter was dismissed for want of prosecution. And in the judge's view, that's not determining the matter on merit, and they would have, he finds that in those circumstances only, the High Court has jurisdiction. Having therefore found that the complaint was not heard on merit, then the election court could have residual jurisdiction to determine the question of qualification of the petitioner. As concerning the issue of alleged irregularities and the illegalities leading to certain findings by the election court, the record shows that the Court of Appeal refrained from making a determination on those issues after it came to the conclusion that the petitioner was not qualified to file for the position of the county governor. That finding, notwithstanding, the Chief Justice has, in his opinion, found that it is in the interest of justice for the Supreme Court to make a determination on those issues. With respect, I disagree with this approach suggested by the Chief Justice. My position is that the appellate jurisdiction of this court is only properly invoked when a matter which was the subject of the Court of Appeal's determination is brought before it. I agree, and it follows that if there is no determination by the Court of Appeal on an issue which is not before it, on an issue which is now before us, how then will the correctness of the decision of the Court of the Superior Court be tested? And with those remarks, the judge concludes that, in conclusion, therefore, and with respect, I disagree with the Chief Justice that this court, I will read that again. In conclusion, therefore, and with respect, I disagree with the Chief Justice that this court has jurisdiction to adjudicate on the issues that were not determined by the Court of Appeal. Indeed, those matters were not canvassed before this court, and the parties recognized by the direction of this court that the only issue that fell for determination by this court was the question of the academic qualification of the petitioner. Having so said, it is imperative that the Court of Appeal and any other court whose decisions are subject of appeal must determine all issues placed before them. To decline the obligation to do so would only lead to a situation such as the one explained above, which does not augur well for the determination of justice. Consequently, save for the above comments, I concur with the decision of the Chief Justice, and I'm in agreement with the orders he has proposed. However, as the majority is of the contrary opinion, the final orders shall be as proposed by the majority. That's the end of the Senora. Now I will give my brother the opportunity to read the majority judgment of the court. Thank you.
This is the majority judgment of the court. The petition of appeal before the court is dated 3rd May 2018 and lodged on 7th May 2018. The petitioner seeks to challenge the judgment of the Court of Appeal sitting at Nairobi in election petition number 2 of 2018. The appellate court, in its judgment dated 20th April 2018, dismissed the petitioner's appeal and in so doing upheld the decision of the election court, which had nullified the election of the petitioner as governor of Wajir County. Now, we have set out the background. We have paraphrased as best we could all the submissions by counsel, and as the Honorable Chief Justice has indicated, these copies shall be available at the end of delivery, so I don't see the reason why I should read that substance. I'll therefore go quickly and straight to the analysis. From the grounds of the appeal, the issues raised by the interested party, the respondent's notice of omission, the Court of Appeal decision, and the rival submissions tendered by the parties, in our view, four main issues arise for determination which will dispose of this appeal. And these are, one, whether this court has jurisdiction to entertain this appeal. Two, whether the High Court, sitting as an election court, has jurisdiction to entertain a pre-election dispute arising from nominations, notwithstanding the provisions of 884E of the Constitution and Section 74(1) of the Elections Act. Three, whether this court has jurisdiction to determine issues that were never addressed by the Court of Appeal. And four, whether or not the appellant herein had the requisite academic qualification to vie for the position of governor for Wajir County. Now, as to whether the Supreme Court has jurisdiction to entertain this appeal, the first and second respondents, the interested party, argued major grounds on which the first two superior courts based the decision was the appellant's lack of academic qualification under Section 22 of the Election Act to vie in the election. And according to them, that did not involve the interpretation or application of the Constitution. The appellant, through counsel, on the other hand, argued that this appeal is well founded on Article 1634 of the Constitution. Now, it is now settled that a court cannot arrogate to itself jurisdiction through craft of interpretation. The court's jurisdiction is donated by either the Constitution or statute or both. And the court's jurisdiction is not a matter of procedural technicality, but one that goes to the root of the court's adjudication process. On this court's jurisdiction, it is clear from our prior decisions that Article 163 of the Constitution, 4A and B of the Constitution, that not all decisions from the Court of Appeal, not all appeals lie to this court from the Court of Appeal. And under Article 163.4A, upon which this appeal is based, only issues founded on constitutional interpretation or application, and where such issues have been canvassed and have formed the basis of the Superior Court's decisions can be entertained by this court. Now, the question as to who is eligible for election as county governor is provided for by the Constitution. Towards this end, Article 182 thereof provides that to be eligible for election as county governor, a person must be eligible for election as a member of the county assembly. On the other hand, Article 1931 provides inter alia that unless disqualified under Clause 2, a person is eligible for election as a member of a county assembly if the person is a registered voter, satisfies any educational, moral, or ethical requirements prescribed by this Constitution or an Act of Parliament. It therefore follows that Section 22(1)(b)(2) of the Elections Act is clearly a derivative of the provisions of Articles 182 and 193(1) of the Constitution. And in interpreting the said section, therefore, the Court of Law has to measure and balance it against these constitutional provisions. We agree with the appellant that the issue of his academic qualification for election as governor of Wajir County was central in the proceedings. But even more compelling regarding the question as to whether this court has jurisdiction to entertain this appeal is the fact that we are also being called upon to determine whether an election court has jurisdiction to determine pre-election disputes, notwithstanding the provisions of Article 884E of the Constitution. And for us, there can be no clearer issue requiring the input of this court at the interpretative and application level. We have no doubt, therefore, that this court has jurisdiction to determine the appeal. Now that brings us to the second critical issue, and whether an election court has jurisdiction to determine pre-election disputes, including disputes relating to or arising from nominations, notwithstanding the provisions of Article 884E of the Constitution and Section 74(1) of the Elections Act. Now, the question as to whether an election court has jurisdiction to determine pre-election disputes has been extensively considered by this court in two recent decisions. in Silvers Lesamola Anami IBC, we were cognizant of the fact that there are conflicting decisions by election courts and the Court of Appeal on this matter. On the one hand, the courts have held that pre-election disputes, including those relating to or arising from nominations, are a preserve of the IBC under Article 884E of the Constitution. On the other hand, the courts have held that notwithstanding the provisions of the foregoing article, election courts retain what we call a jurisdictional residuum to determine pre-election disputes. In addressing these conflicting judicial opinions, at paragraph 54, we rendered ourselves thus, and I quote, "How do we resolve the apparent conflicting positions taken by the Court of Appeal and election courts? Our view is that Articles 884E and 1051 and 3 must be read holistically, and that whereas the IBC and PPDT are entitled, in fact empowered by the Constitution and statute to resolve election disputes, including nominations, there are instances where the election court, in determining whether an election is valid, may look to issues arising during the election period, only to the extent that they have previously not been conclusively determined on merits by the EBC, PPDT, or the High Court, sitting as a judicial review court, or in exercise of its supervisory jurisdiction under Article 1653 and 6 of the Constitution. Where a matter or an issue has been so determined, then the election court cannot assume jurisdiction as if it were an appellate entity, since that jurisdiction is not conferred on it by the Constitution. In Samindungu Haiti versus IBC and 3 others, this court, in a majority decision, extensively reviewed the decisions of the High Court and Court of Appeal regarding this question. The court emphasized the fact that the Constitution has to be interpreted holistically and purposively, and that the Constitution, being a living charter, is always speaking, and that in interpreting its provisions, a court of law must keep in mind that the Constitution cannot subvert itself. Towards this end, every constitutional provision supports the other, and none can be read so as to render the other inoperable. And at paragraph 67, the court stated, "In our perception, this conflict cannot be resolved by either discounting one school of thought or wholly embracing the other. What is critical, in our view, is the need to harmonize these well-reasoned opinions so as to give effect to both Articles 884E and 1051 and 99 of the Constitution, as read with Section 75(1) of the Elections Act. Doing so would be to stay faithful to the edict that the Constitution must be interpreted purposively and holistically, so as to ensure that Article 884E of the Constitution is not rendered inoperable, while at the same time preserving the efficacy and functionality of an election court under Article 105 of the Constitution. This court has developed the following principles, and I think it serves that I read them. 1, in all pre-election disputes, including those relating to or arising from nominations, all pre-election disputes, including those relating to or arising from nominations, should be brought for resolution to the IBC or PPDT, as the case may be, in the first instance. 2, where a pre-election dispute has been conclusively resolved by the IBC, PPDT, or the High Court, sitting as a judicial review court, or in exercise of its supervisory jurisdiction under Article 16536 of the Constitution, such dispute shall not be a ground in a petition to the election court. 3, where the IBC or PPDT has resolved a pre-election dispute, any aggrieved party may appeal the decision to the High Court, sitting as a judicial review court, or in exercise of its supervisory jurisdiction. And the High Court shall hear and determine the dispute before the elections and in accordance with the constitutional timelines. 4. Where a person knew or ought to have known of the facts forming the basis of a pre-election dispute and chooses through any action or omission not to present the same for resolution to the IEBC, such dispute shall not be a ground in a petition to the election court. 5. The action or inaction in 4 above shall not prevent a person from presenting the dispute for resolution to the High Court, sitting as a judicial review court, or under Article 165(3)(6) of the Constitution, even after the determination of an election petition. 6. In determining the validity of an election petition under Article 105 of the Constitution or Section 75(1) of the Elections Act, an election court may look into a pre-election dispute if it determines that such dispute goes to the root of the election and that the petitioner was not aware or could not have been aware of the facts forming the basis of that dispute before the election. We believe that the foregoing principles may pave the way in streamlining the electoral dispute resolution processes, both at the pre-election and post-election stages. Applying the reasoning in Sylvester Lesamula and Sami Waita, alongside the foregoing principles to the instant case, we note that a complaint had been lodged before the IEBC Dispute Resolution Committee by Mr. Abdurrahman Mohammed Abdile, questioning the suitability of the petitioner vie for the position of county governor. IEBC Dispute Resolution Committee dismissed it for want of prosecution. The respondent herein did not file any complaint to the IEBC questioning the petitioner's academic qualifications, nor did he pursue the original complaint which had been lodged by Mohammed Abdile. In fact, he is on record as stating that he had all along been aware of questions surrounding the petitioner's academic qualifications, not just in 2017, but since the year 2013. On both occasions, he chose not to lodge any complaint at the IEBC until after the elections of 2017, when the petitioner had been declared the winner of the election. In other words, the first respondent decided to ignore or overlook the clearly established constitutional mechanisms for resolving re-election disputes until after he had lost the election. What are we to make of a situation where a contestant ignores the Constitution, drags an entire county through a grueling election, only to turn around and intone that his rival was not qualified to vie in the first place? Is an election court to assume jurisdiction over such a dispute in such circumstances? We think not, if we were to allow contestants or any other person to consciously incubate a dispute by passing the Constitution and originating it an election court. That would surely render Article 884E of the Constitution inoperable. For if one can originate any dispute at the election court, why bother with the IEBC? The IEBC in relation to election disputes would surely become obtuse. It is in this regard that we developed principle number 4, which we have already adverted to. In Lisamola, the question as to whether the third respondent therein was a registered voter had been determined by the IEBC Dispute Resolution Committee. No appeal was preferred to the High Court, or sitting in as a judicial review court or in a supervisory capacity. This court, in holding that the matter could not be revived at the election court, stated, to put our holding into context, therefore, there is evidence that the question whether the third respondent was a registered voter was determined by the IEBC Dispute Resolution Committee, which resolved that the names refer to the same person. No appeal or judicial review proceedings were instituted to challenge that decision, and although the petitioner was not a party to the proceedings, it has not been shown that he was unaware of them, or that when he became aware of the same, he took any action, save filing of the election petition before the election court. On what basis can this court now find otherwise? And we submit none. In any event, the decision of the quasi-judicial body within the IEBC stands, and it has never been overturned. The election court and the Court of Appeal were bound by it, and therefore properly declined to assume jurisdiction in the matter. We see no reason to overturn the decision. And similarly, in Waiti, the majority decision, we rendered ourselves thus. Accordingly, the question as to the validity of the second respondent's independent candidature only arose in the election petition filed in the High Court. The petitioner, having been chief agent of the Jubilee Party for Laikipia East constituency, knew all along, or ought to have known, that the second respondent had quit the party and would be contesting the ensuing election as an independent candidate. With this knowledge, he chose not to challenge the validity of the independent candidature at the appropriate forum. It is therefore clear that the court places a premium on whether a petitioner had prior knowledge or the facts giving rise to the pre-election dispute. In the appeal before us, one could argue that the pre-election dispute was not determined on merits, since it was dismissed for want of prosecution. As such, it cannot be said to be within the ambit of Article 884E of the Constitution. Such an argument is informed by judicial decisions to the effect that a dismissal of a matter for want of prosecution does not operate as an estoppel in civil proceedings. Such a contention may hold water in ordinary civil proceedings, but not in election disputes where constitutional provisions and timelines are at play. Here, the person who lodged the complaint decided not to prosecute it for whatever reasons. The respondent not only chose not to pursue or revive the complaint, he chose not to lodge any complaint at all. So the complaint that was dismissed for want of prosecution was not his complaint. On the basis of the foregoing reasoning, we find and hold that both the election court and the Court of Appeal wrongly assumed jurisdiction in determining what was clearly a pre-election dispute regarding the academic qualifications of the Commission. However, as our principle number 5 above stipulates, a petitioner's inaction does not prevent him from presenting the dispute for resolution before the High Court, sitting as a judicial review court, or in exercise of its supervisory jurisdiction under Article 165 of the Constitution. This principle, as read with principle number 6, means that at any time, the judicial process is never closed. It also preserves the authority of the Constitution in the event of the occurrence of certain tragedies to which our attention has been drawn. For example, what would happen if a person who is not a citizen of Kenya were to slip through the IBC vetting process and become elected MP, governor, or even president? Or what happens if a person who is not qualified as provided for by the Constitution slips through the IBC vetting process and gets elected? The answer lies in these two principles. In one instance, where the tragedy was not known, the election court assumes jurisdiction. In the other instance, where the tragedy was known, the High Court takes over under Article 165 to preserve the Constitution. This interpretative framework is not only holistic and purposive, it is also forward-looking. After all, whatever can slip through the IBC vetting process can also slip through the election court petition processes. At the end of the day, the constitutional pre-election dispute resolution mandate of the IBC is respected, the efficacy of the election court is preserved, and above all, the authority of the Constitution is intact. Now, issue number 3, whether this court has jurisdiction to determine issues
KTN News. Get the whole story.
Normally, we don't taste the food before offering the dog.
This is KTN News.
In this regard, we are in agreement with Justice Lenaola's opinion on this question as expressed in paragraphs 203, 204, 205, 206, and 207 of his dissent. We have made certain observations as to the issue relating to additional evidence.
That the petition of appeal dated 3rd May 2018 is hereby allowed. Number 2, the judgment of the Court of Appeal dated 20th April 2018 is hereby set aside. Number 3, for avoidance of doubt, the declaration of the result of the election by the Independent Electoral and Boundaries Commission in respect of the Governor of Wajir County is hereby upheld.